Hi there, I'm James Dafferty, and this is Coffee in the Case Note. Opaque and exceedingly complex was the phrase that the court used to describe the arrangement we're going to be considering today. So you'll forgive me if I paint with broad brushstrokes. I'll send you a link to the judgment. You can read it as well if you'd like. So, to oversimplify, we're dealing with two parties, the arrangements between whom were opaque and exceedingly complex. But in essence, the two parties are involved in an enterprise whereby I'll say the UK party or the big overseer party causes tech to be produced, docking stations and various electrical things. And the Australian party, or what we might think of as the smaller party, the sub-party, then sells those in the Australian-New Zealand market fairly. And just imagine if that explanation was both opaque and exceedingly complex, and we might have some understanding of the factual arrangement. Now, this relationship goes on fairly well for a good 15 years, I think, from about the mid-90s, so what's that, 20 years, until it develops in a direction that is less collegiate between the parties. In around 2017, the UK party decides to slap a 10% surcharge on its invoices. And if I can just take you into the technicalities, the way the arrangements work is our Australian distributor orders parts from the factory. The factory invoices our UK entity. The UK entity then invoices the Australian entity, and add about 1,000 more steps to that arrangement, and we're somewhere near understanding what it is. So let me set out what this 2017 change is. The 2017 change, or around 2017 change, is that the UK entity says, right, in respect of these docs, this tech, we're now going to add 10% to this invoice that we're going to send you in relation to the production of this tech that you then go on to sell in Australia and New Zealand. What they also say is, hey, you can't place these orders anymore. So the UK entity says 10% on this invoice and tries to end this relationship between the Australian seller and the factory itself. Proceedings are commenced. The proceedings are the UK entity suing the Australian entity for this 10% surcharge, including backdating the 10% surcharge to 2001, meaning that the surcharge is several $1 million, which is a surprising and intriguing thing to do. And what they also do is say, stop placing these direct orders. And what they also do is require, rather than 60-day terms, they require cash on delivery. There's a big claim. And as part of this big claim, our Australian entity makes a monstrous cross-claim that thankfully we're not going to dive into today. But in the judgment, it says the cross-claim 74 pages long with a table of contents. So it's serious, big piece of litigation. What we're discussing today is a interlocutory injunctive application within that big litigation. And the interlocutory injunction is sought by our Australian party. What they essentially seek is two things. Firstly, can we please get a hold on the 60-day to cash on delivery arrangement? And they seek a hold, essentially, or a pivot with the various delivery times. The Australian entity also alleges that there are real delays that are being caused by the UK entity about these delivery times. And that's part of a pattern of what the Australian entity says is unconscionable conduct that takes apparently 74 pages to explain. But in essence, our Australian entity wants injunctive relief, restraining this cash on delivery requirement, and a number of other pivots to the contractual arrangement to in order them to go on in business as the big final hearing for the huge piece of litigation approaches. So what we're discussing today is that interlocutory injunctive application. Now, in order to succeed in getting injunctive interlocutory immediate relief, what you have to convince the court is that you've got a good claim, and that the balance of convenience favours you. You also need to give an undertaking as to damages, and we'll talk about that later as well. But essentially what our Australian entity says is, here's a huge record of our cash flow. If we shift from 60 days to cash on delivery, it's going to make a bit of a mess of our business and put us at risk. And, which the court accepted, second thing the court accepted was that there was no evidence that the UK entity would be damaged too much by retaining the 60-day arrangement. So that element of the injunctive relief, the balance of convenience, the applicant favoured our Australian party, so bang, the injunction restraining that cash on delivery arrangement, granted. A number of other injunctions that were sought by our Australian applicant related to delays and timing and various other things, but essentially those were not granted. And so we find ourselves in a position where our Australian entity got a big old tick for the cash on delivery element of the injunction, but went down on a number of other prayers for relief that it sought by way of interlocutory application. So we then, as I told you we would before, we turned to the undertaking as to damages that was given by the Australian entity, or that was required to be given by the Australian entity in respect of this injunction. That's what you got to do if you want immediate injunctive relief. Now, what I haven't told you is that our UK entity is a 51% shareholder in the Australian entity, and this big piece of litigation is a bit of a dispute between how our UK entity wants to run things, our 51% shareholder in the Australian entity, and how our 49% shareholder in the Australian entity wants to run things. And in the circumstances, what the court found was that the undertaking as to damages ought not be given by the entire Australian entity, as it were, because that would impact potentially to the point of 51%. The UK entity, which is the other side of this injunction, which is the respondent to the injunction. So what the court ended up doing was seeking and getting an undertaking as to damages from this 49% shareholder. I think we said opaque and exceedingly complex. Hope you agree with that. The final question was as to cost, and there was no order made. And what the court noted in one of the later paragraphs in the judgment was, there will no doubt be arguments as to costs. Truer words never spoken, perhaps. So I hope today's judgment, guys, illuminates some of the difficulties with seeking immediate injunctive relief, but also some of the circumstances in which you can get it. And I also hope that you enjoyed a bit of an adventure through some exceedingly complex and opaque facts. I look forward to joining you for another coffee and another case note soon. Cheers.